It is my privilege and honor to call upon Honourable Binnie to come and join us for the next half an hour, 45 minutes, and of course for the rest of today. As my colleague Leah suggested, she's also she's been called for a year. I've been called for 10 years, so I've spent many nights, many days dissecting the 170 cases, I'm not going to say I read all 170, that you have been responsible to oversee at the Supreme Court of Canada in your 14-year-long tenure serving as a Justice of the Supreme Court of Canada. So with that, I'm deeply honored that you're able to join us today and share your wealth of experience and knowledge as a Justice of the Supreme Court of Canada. So Honourable Binnie, please come to the stage.
Well, thank you very much. It is a great privilege to be part of this forum. It's very educational from first to last. It is too bad, really, that the Stephen Point is not put on national television to give the address he gave this morning, as it brings reality to many of the concepts which people have heard of, they understand, but they don't have the kind of emotional power that Stephen Point brings to the subject. I have a more mundane task, which is to talk about the courts. And the notion is to take the long view, because I actually argued my first case involving native hunting in the Supreme Court 50 years ago, 1966. A hunting case from Kettle Point in Lake Erie, where an Aboriginal person had shot a duck for food and was prosecuted under the Migratory Birds Convention Act, which had an exception for Aboriginal people hunting for food, but the exception was ignored by the Government of Canada, was not put in the regulations, and the Supreme Court said, well, that's too bad. It's not in the regulations. The conviction will be upheld. So we've come a long way, and whatever frustration you feel here and at the various tables, you have to put in perspective of just how far your cause and the cause of reconciliation and justice has moved in that period of 50 years. Now, when Section 35 was introduced, I was in the Department of Justice, and nobody really knew what it meant. Trudeau the senior, was asked what he thought he meant, and he said he really didn't know, but that the courts could not do a worse job than the politicians had done in addressing the ongoing issues of First Nations. I want to sort out some of the basic ideas here as to what the courts can do and what they can't do. Stephen Point has outlined in a memorable way the content of nationhood and what it means, and it's not a legal concept. I mean, you are a nation. The Haida is a nation because the Haida say they are a nation, and the Squamish and Musqueam and everybody else. The Parliament of Canada has recognized French Canada as a nation. Doesn't mean it's separate and apart and outside the constitutional arrangement. It is simply recognizing social, historical, linguistic, cultural facts. But that is quite different from the notion of sovereignty and self-government. the one does not necessarily imply the other. And for a long time in this country, the law was confused between the notion of sovereignty, which the courts resisted in relation to First Nations, and self-government, which the courts did not particularly resist. And in fact, in 1973, in the Calder case, with which you're all familiar, Justice Judson said, look, Aboriginal title is really a desire of the Aboriginal people to carry on living on the land as their forefathers had lived. That's the way he expressed it. And of course, the way in which the forefathers and foremothers lived included self-government. I mean, it wasn't everybody for themselves. There were institutions of government historically across the country. I don't think anybody's ever doubted that. The problem comes in trying to fit the different pieces of what is Canada together. And reference was made yesterday to Section 91 and Section 92 of the Constitution, and I think Miles Richardson said, look, sovereignty is about power. Who has the power to do what? And I think that ties into what Stephen Point was saying about the importance of a constitution. But sovereignty as such really belongs to all of the people who live in the geographic area of Canada. As the Americans put it, we the people. Now, in our archaic constitutional method, as again Stephen pointed out, there's the notion of the Crown, and the Crown is the sovereign and so on, but that's all just bafflegab. I mean, nobody believes that Prince Charles has anything to do with what goes on in Canada, or ever will have anything to do with what goes on in Canada. The Royal Commission on Aboriginal Peoples talked about merged sovereignty. It tried to get away from the idea that, well, we're sovereign and we're not you and you're different from us, and said, look, the reality is that there are a number of constituencies, community of communities in Canada, and together, collectively, they exercise sovereign power. So the question is, how do you allocate that power amongst different institutions, First Nations, provinces, territories, federal government? And as was mentioned yesterday, in the Constitution, there's a list of powers. The provinces have authority over property and civil rights. The federal government has authority over defense. And it was said, well, you should go through the list of powers and decide which ones do First Nations insist on, such as families and children. Which powers are you willing to share? And which powers are you really not interested in taking on, such as, I would think, currency? I mean, do you really want to issue your own currency and have exchange rates within the country going up and down? Issuing passports, which run into trouble internationally. So there has to be some kind of thought given to not nationhood, that's a given, not sovereignty, because First Nations are as much part of the sovereignty of Canada as any other group within Canada. The question is this allocation of authority. And it strikes me that that is where the treaty-making process and the focus on self-government and governance takes on importance, because it has to be defined, it has to be written down. Stephen Point mentioned, well, England doesn't have a written constitution. But that's because England is a unitary state. It doesn't have provinces, it doesn't have territories. It is simply one conglomerate. and therefore they can make rules as they go along. But if you divide powers between First Nations and the federal government and the provinces, it has to be written down as to who has the authority to do what. And it doesn't really create a hierarchy of sovereignty. It is basic constitutional law that the provinces, for example, are as sovereign in their areas of jurisdiction, such as family law, as the federal government is in its. The notion that Canada is the sovereign is, as a matter of law, wrong. Sovereignty lies in the entity which is exercising the authority under the Constitution in relation to a particular matter. And therefore, the importance of the treaty negotiation is to spell all of that out. Now, I understand the frustration that is so evident in this room at the treaty process. I do quite a lot of mediation, mainly in Ontario, and a number of First Nations claims. I know how difficult it is to get anything out of the province of Ontario, even when it's not simply dealing with a claim, it's dealing with a court case that it's on its way to trial. They still can't get instructions. They still can't get their act together. They can't decide what they're prepared to do and what they're not prepared to do. And it strikes me that from the First Nations perspective, you have a great advantage if you can get your act together and make a proposal that they have to react to, instead of allowing them to come forward with proposals which are going to lowball. They're going to try to extricate themselves from the situation at what they see as least cost. And I have always felt, dealing with government, and for a time I was in government, that government is much more capable of reacting than to taking the initiative. And I have also found, and this might not be an agreeable thing to say here, but in matters I've been involved negotiating, it is very often disunity on the Aboriginal side that has torpedoed the venture. For years, I was one of the negotiators on the Algonquin claim to the Ottawa Valley. Mike Harris was the premier, hard hat Harris. Harris was prepared to do a deal because Harris had a constituency in the Ottawa Valley and he wanted stability. And the problem was that the First Nations couldn't get on the same page with the Métis, who couldn't get on the same page with the non-status Indians. The Aboriginal side of the table fell apart, and the negotiations stalled for 10 years. So the emphasis that you have been putting in the last, well, I've been here at the forum, on unity, on developing a coherent position, on pressing that position is exactly right. And then the thing to do is to get it committed to a treaty document. So what can the courts do in this process? And I think it's important to emphasize that the court started with virtually a blank page. Section 35 recognizes and affirms existing treaty and Aboriginal rights. What that referred to, if it referred to anything, was the sort of British colonial law which held that when the British overran a part of the world, it didn't belong to them, the laws in that part of the world continued until Britain imposed a different set of laws. So it was a survivor legal system. And that was the notion of the rights of Aboriginal peoples, and there are cases from all across the British Empire, as it then was, on that concept. And that is why when we talk about reconciliation, we have to understand that reconciliation has evolved enormously in the last 30 years. Reconciliation originally, under colonial law, meant just to reconcile yourself to the fact the British had taken over. In the same way, if you're going to live in Vancouver, you reconcile yourself to the rain. You might not like it. You're not sort of getting together with it. You're just facing realities. You are reconciling yourself to that. And that, if you look at the early cases in the Supreme Court, including Delgamuukw and Gladstone, that's the way they're using reconciliation. It is the reconciliation of Aboriginal First Nations with the sovereignty asserted by non-Aboriginal nations. But then that has evolved, and reconciliation suddenly became a reconciliation amongst peoples, not sovereignty clashing with sovereignty, but communities. That somehow there had to be a workable arrangement that was acceptable and fruitful both to the Aboriginal communities and to the non-Aboriginal communities. And that's a totally different notion of reconciliation, and it was simply created by the courts as it shifted the focus from the early concept of Aboriginal law to what it has now become. The courts have equally reshaped the notion of the Crown. Initially, and I'm talking in Canadian history going back to the 1800s, the Aboriginal rights were considered to be held at the pleasure of the Crown. This concept of, your laws continue until such time as they are altered. And if the Crown manifested its pleasure that the city of Vancouver would be parceled out to private interests, the sovereign had shown its pleasure, and the title was, on that theory, extinguished. That concept has also been turned on its head. What we now talk about, as discussed through this forum, is the honor of the Crown. It's no longer that the Crown has the whip hand to show its pleasure and get its own way. The Crown is now subject to a limitation, an obligation, a restriction that it must act honorably in relation to Aboriginal peoples. And this concept just appeared. It has been referred to from time to time over the years, but it was a case involving bullfrogs at Curve Lake in Ontario, where there were witnesses to the original treaty, which made it clear that hunting and fishing during the oral discussions included the taking of bullfrogs, which was an important food source. That did not appear in the treaty. And the province said, prosecuting somebody for taking bullfrogs out of season, it's not in the treaty, it doesn't exist. And the court said, the honor of the Crown will not permit the Crown to deny what is clearly on the evidence, an undertaking as to the scope of that treaty. And then the honor of the Crown was picked up in a number of subsequent cases. It became the ground of the duty to consult. That's based on the honor of the Crown. It's now become a constitutional principle. Manitoba Métis, a case which I think 25 years ago nobody thought had any chance of success. The Supreme Court says it is not consistent with the honor of the Crown to have done the Métis people out of 1.4 million square miles of land and to deal with the scrip and so on. So it has become this huge weight imposed by the courts on the Crown to live up to the concept of honor. And it was manifested yesterday when you were talking about good faith negotiations. That too is an obligation imposed by the honor of the Crown. But the point I'm getting at is that while the hard work of negotiations is left to the people in this room and those you're dealing with at the various tables, the courts have done their best to create a framework within which those negotiations can fairly take place and lead to a lasting result. Now, when you talk about reconciliation, there is a bit of a twist on it, which emerged in Chilcotin in the trial judgment, and that is that reconciliation not only has to be fair to Aboriginal peoples, but it has to be fair to non-Aboriginal peoples. Reconciliation is not a one-way street. And Judge Vickers said that Chilcotin people must find an accommodation that reconciles the historical Chilcotin place in Canada with the place of their neighbors who come from all corners of the world. So yes, reconciliation has taken a giant step forward in dealing with the relationship amongst communities, but it has also imposed not only an obligation on non-Aboriginal governments to deal fairly with Aboriginal people, but for Aboriginal people to recognize the legitimate concerns of non-Aboriginal people. And this, in fact, was borne out in Chilcotin, where they said, ultimately, look at that part of the claim area which is occupied by private interests and so on. That's no longer part of our claim. And I think that had a good deal to say in why the court was inspired to do what it did in that case. The nature of the Crown interest in land. Yesterday we heard from Miles Richardson, well, the underlying interest in the land belongs to Aboriginal people because their roots are deep in the earth. And he said on top of that sits the Crown, suffocating the Aboriginal interest. And historically, the courts have said that the underlying of the interest of the Crown is paramount, that the Aboriginal rights are an interest over that of the Crown, which is dealt with by extinguishment. Now that has been flipped. In Chilcotin, the court says, what is the relative interest of the Chilcotin people with the Aboriginal title and the Crown? And what the Chief Justice said, which is a staggering statement in terms of the evolution of the law, the content of the Crown's underlying title is what is left when Aboriginal title is subtracted. So you start with Aboriginal title, you take a measure of its contours, and what is left is the Crown's. It's a complete reversal. And it's done in a couple of paragraphs. Boom, the Crown's gone. It's now suffocated under, to use yesterday's language, the interest of the Aboriginal title. And when you go back historically and you see the development of the law, that the law of discovery, the Europeans coming to North America, laying claim to these lands, and that the right of discovery gave each of these nations the exclusive right to make treaties and take over the lands. There's 200 years of history that have now been blown away by the latest twists in the doctrine, which again seems to me a giant leap forward for the Aboriginal people. And what about Aboriginal title? I mean, Chilcotin is a decision of absolutely staggering importance in terms of the development of Aboriginal law. Traditionally, the courts have said, well, Aboriginal rights, and of course the word Aboriginal title does not appear in the Constitution. Aboriginal rights are a bundle of different hunting, fishing, gathering, what have you. It's not title. Then the idea of title began to surface. It surfaced a bit in Delgamuuk, it surfaced again in Adams, although that was a fishing case. And it suddenly emerged full bloom in Chilcotin. And what is said about Aboriginal title? Well, it is said to include the control and use and benefit of the lands. How do you control the use of the lands if you don't have self-government? How is this control to be exercised? Surely it has to be implicit in the notion of Aboriginal title that inherent is the right of self-government to that territory. But then there is the rider that says, yes, you have this superior title, and it goes beyond fee simple, it goes beyond the highest interest that, for example, I can have in a piece of land, because Aboriginal title cannot be expropriated, unlike my little piece of land, which can be taken for a highway because somebody feels like putting a highway there. They have to go through a very high level of justification going back to the Sparrow case. They have to show that the objective is pressing, important, proportional, and all the rest of it. But then there is the limitation that you are stewards of that land subject to the title. It is for future generations that the use of the land cannot impair its availability to future generations. Now, I don't know what that means, for example, with non-renewable resources. What you do with the, if your Aboriginal title is sitting on oil deposits. Can you take the oil, or does that deny future generations the benefit of that resource? And if it remains in the ground, does anyone ever get the benefit of the resource if, in fact, you want to take advantage of it? So there are many questions to be worked out in terms of Aboriginal title, but it strikes me as crucial that these things be explored within the First Nations community so that you have a position to put forward when the governments sit down and say, all right, where are we at in pursuing this matter? I want to talk a little bit about the role of history in Aboriginal rights. I've always thought that it's somewhat unfortunate, although it was an outgrowth of the British common imperial law, that there's so much focus on what were the practices, uses of Aboriginal people at the time of contact, and was it part integral to the distinctive society and so on. Because that really doesn't focus on what you want solved, which is a viable form of self-governing institutions on a legitimate, reasonable resource base. And it operates unfairly because in some parts of the country, the traditional, for example, fishery was a matter of great wealth. In other parts of the country, the rights have very little value at all. Important thing about Aboriginal title in the Chilcotin case is that it struck the whole notion of the historical shackles down. It said, we're not limiting the use of those lands to historical uses. Those lands can be used for any purpose compatible with the stewardship for further generations. And surely that's the way it should be. I mean, you shouldn't be trapped forever in what life was like or rights that were exercised at the time of contact. And if you're dealing with First Nations across the country, surely there should be some kind of equity so that the Samson Band in Alberta sitting on these huge oil reserves are not so much better off than the Sweetgrass Reserve in Saskatchewan, which effectively has virtually nothing. Self-government, I just want to add a word to what I said before. That has always been a concern of the courts. They don't know how Aboriginal self-government would fit with the provinces and the federal government and the territories. Nobody has ever really come from the Aboriginal community and say, here is the list, here is the catalogue of powers that we seriously require and wish to negotiate and have incorporated in a treaty. So in a case called Pamawidjawan dealing with gambling, the court said, and the First Nation said, well, look, gambling is part of our self-government of the reserve. The court said, well, we're not dealing with self-government. We'll deal with each discrete right. Did you have a right at contact to regulate gambling? Well, who can possibly answer that question? Nobody can answer that question. So it looked at that point that self-government was simply not going to be addressed by the courts. And I dare say it won't be addressed by the courts unless there is a proposal that comes forward, a treaty, which sets out powers of self-government, which the court can then deal with in specific terms. I do not believe, Lord knows I've been proven wrong enough, I do not believe there will ever be a judicial declaration, yes, there is an inherent right to self-government. They have done it in relation to Aboriginal title, but it remains to be seen just how many areas of this country will be found to be covered by Aboriginal title. One last point. It was said yesterday that only the federal government, only Canada can make treaties. And traditionally that has been the case. Federal power over Indians and lands reserved for Indians. I don't think that is any longer the case. I think what the Supreme Court of Canada is now saying is that the First Nations deal with the province in the same way that First Nations deal with the federal government. In terms of the Forestry Act at issue in Chilcotin, the court said, yes, the Provincial Forestry Act would apply, although in that case it didn't because the timber was no longer crown timber, but they could amend the statute and it would apply as a law of general application to the forests of the Chilcotin people. The question, however, is if at that stage the province wanted to issue a cutting license, it would first have to consult with the Chilcotin people. And the Chilcotin people might agree to certain cutting rights, and that would have to be incorporated in a treaty. That's what the contract, the agreement, the outcome of the consultation would be called. So just as these giant comprehensive treaties, agreements, are called treaties, so would individual agreements between the provincial government and the First Nation dealing with the abridgment or modification of the Aboriginal title. So you've now got a far greater presence of the province in this whole issue than you did before, because it's really not limited to Aboriginal title. In areas that are under claims throughout British Columbia, if there's conflict between the First Nations and the province has the obligation to consult, and what comes out of the consultation is an agreement with the province, not the federal government, because it is the province that has the resource, the authority and title to the resource subject to the rights of the First Nation. So I think how do you get the federal government and the provincial governments to negotiate in good faith? I think you do that by getting your own act together. I think you do that by showing a united front and stop this fragmenting and the capacity to divide and conquer. I think the First Nations have to seize the initiative, because I don't see the governments doing that. And I think that the courts will continue to apply a prod to the governments to negotiate by making it clear to the governments they have more to lose by not settling than they do by settling. And it's only when the governments understand that balance that is operating in favor of settlement that they will really come to the table and make the deal that you're looking for. So, thank you very much.